Rule of law under attack. I'll make it a little more specific. We're going to talk about civil forfeiture. And I know that's been a theme in this room already today. But I'm going to take a slightly different approach to it, and I'm going to tell you what's wrong with it in a very, hopefully, specific way, and then give you lots of concrete examples that should make your skin crawl. And my goal is to convince you that, at least the way it currently exists, and probably, I would say, any instantiation of it, is probably a bad thing. And just as a little forward here, I know a lot of people who look at civil forfeiture and say, well, civil forfeiture is bad, but no one has any problems with criminal forfeiture. Well, let me tell you, in the last 2 years, I've discovered there's problems with criminal forfeiture as well. So don't keep the baby when you can throw it out with the bathwater, I guess. I'm not sure how that would work. So anyway, my name's Derek Fromm, and I'm a Calgary lawyer, and I work at the Canadian Constitution Foundation. Love it if you donate to us. We're a charitable organization. We defend people who have their rights infringed by the government. Have to say that. Sorry, Matt. I know we're competing in some ways. Now, I'm going to talk about civil forfeiture. If you don't know exactly what that means, just sit tight. I'm going to explain it and hopefully give you some good reasons and plenty of examples as to why it is not the unqualified success that most provincial governments want you to think that it is. So, what is civil forfeiture? Well, there's two words, civil and forfeiture. Well, civil forfeiture laws permit provincial governments in Canada to initiate court proceedings to forfeit any piece of property that is suspected to be an instrument of crime or that is suspected to have been acquired with the proceeds of crime. The government only need prove its case on the balance of probabilities, and there's no conviction required. So, what can possibly go wrong with this? I'll give you a tip. Sometimes there's no victim, and you can have your property taken. Sometimes there's no conviction. You can have your property taken. Sometimes you might be an innocent third party, and you can find your property taken. There's definitely no proportionality between any sort of crime that is alleged, has been committed, that you're accused of, and what they take from you. No proportionality. And probably worst is that there's actually perverse incentives, meaning that the people who are enforcing these laws often have an incentive to enforce them more harshly because they personally gain from them. So forfeiture itself, what does it mean to be forfeited? Well, forfeiture is the deprivation or destruction of a right as a consequence of some unlawful act or omission. And in the case of property forfeiture, it's a deprivation or destruction of the right to your property. For example, in civil forfeiture, if your house or car is forfeited, your right to possess and own that car is extinguished. Title passes to the government. So why is civil forfeiture civil and not, for instance, criminal? Well, as you likely know, there are two common standards for proof in law. The first is the so-called beyond a reasonable doubt. This is what is used in criminal proceedings. And without relying on any sort of false precision, we can't really quantify this in a mathematical way, but it'd be something akin, to 99% certainty, or that a reasonable person would have no doubt that you did it. That's what beyond reasonable doubt means. So, the second standard of proof is what's called on the balance of probabilities. And this is 50 plus 1. So, this is the civil standard of proof, and basically it means that the prosecution in court must demonstrate that on the preponderance of evidence, it supports the case against you. And this is a far lower standard than the criminal standard. So, which begs the question, what does the Crown have to prove when they come after your property? Now, because civil forfeiture applications use this lower standard of proof, the Crown must only prove on the balance of probabilities that a piece of property is more likely than not to have been the instrument of crime or acquired with the proceeds of crime. So, unlike criminal proceedings, there's no requirement that the court or the Crown must prove its case beyond a reasonable doubt. So it's far easier to lose your property. Now, okay, so that's the definitions in the background. Why was this law ever brought in? What's it supposed to do? Well, civil forfeiture laws are supposed to make committing crimes unprofitable. Makes sense, right? You do something that's illegal, and you buy a nice Hummer with it. Well, the government comes along, takes your Hummer, forfeits it. So it does make sense what they're trying to do, and the idea is that no one should profit from their illegal activity. So if we look at Ontario and Alberta, probably the two that I'm most interested in, Ontario's act is called the Civil Remedies Act, and it has 4 purposes in the act. The very first one is to compensate victims. So the victims of a crime, presumably, compensate victims. And then the second is to prevent people who are engaged in unlawful activities from keeping the property they acquired performing those unlawful activities. Okay? And the government can also prevent you from using your property in future unlawful activities and prevent injury to the public. Now, Alberta's has a very interesting title. Alberta's is called the Victims Restitution and Compensation Payment Act. And so right in the act, it says what the act is supposedly for. It's to help those people who have been harmed by crime. Make sense? Well, it says right in the act, the purpose is to provide compensation and restitution to victims, to remove the financial incentive of committing crimes, and to prevent property acquired by illegal means to be used in future illegal acts. It's kind of a different one, right? Okay, so that's what the purpose of this law is. How does the government do it? What powers are these governments given by these laws? Well, Ontario can forfeit property that is, quote, the proceeds of unlawful activity. And that means property that's acquired directly or indirectly, in whole or in part, by unlawful activity. Well, unlawful activity means any act or omission in Ontario that is an offense in Canada, Ontario, any other province or territory. Also, if it's an illegal act in a foreign jurisdiction, and it's likely it would be illegal in Ontario, they will enforce that against you as well. Alberta is maybe less draconian and less broad, but arguably the same results happen. So in Alberta, the government here has the power to acquire or to take your property if it's been acquired by illegal means under the Criminal Code or the Controlled Drug and Substances Act. And then there's also this little stand-in. There's 2 stand-in clauses right after that in this act in Alberta that says, by the way, if we decide that there's some other law that should apply to this, we can incorporate it by regulation. That hasn't yet happened as far as I know, but I think you had mentioned earlier today, Karen, that there was some talk about that previously, about incorporating it. But I haven't been able to find it, but that doesn't mean it doesn't exist, because it is really trying to find a needle in a haystack. Okay, well, Ontario and Alberta both use this. What other provinces? Well, currently there are 8 provinces that have civil forfeiture regimes in place. And I mean regimes, because what ends up happening is when these laws are enacted, an entire office springs into being with staff and lawyers and bureaucrats that are there to enforce this law and manage the property that's being forfeited. So there's 8 provinces. So Ontario was first in 2001. Alberta followed soon after in the same year. And aside from Ontario and Alberta, today British Columbia, Saskatchewan, Manitoba, Quebec, New Brunswick, and Nova Scotia each have civil forfeiture regimes. BC's is probably the most notorious, but I tell you, recently it seems like Ontario is really trying to give them a run for their money. And it also, something I think is very interesting is the government in the territory of Yukon was going to bring in a civil forfeiture act a number of years ago. And this is surprising to me. Yukon voters were actually so aware of the topic, they protested, and the government backed down and did not enact a civil forfeiture law. So that actually surprises me. I wouldn't have pegged it as being Yukon. I would have thought maybe Alberta, but no, Yukon. No act there because people protested. So I guess the real question we need to get to in some ways is how effective are civil forfeiture laws? So their purpose is to strip criminals of their property that they acquire by committing illegal acts. That's really what it comes down to. It's to make crime unprofitable. So crime does not pay. Perhaps we could say that it's for the biker gangs. We don't want them selling drugs and profiting from prostitution, so we're going to take their clubhouse. That's really what it's about, that type of situation. So how effective is it? Does it target criminals, for instance? Well, some of the individuals targeted by civil forfeiture have never been convicted of crime. And there's plenty of examples of that. And that's because, think of the standards of proof. So if you're going to be convicted of a crime, it's a standard that's way up here. It is beyond a reasonable doubt. Well, if the government can't make its case against you for the criminal conviction, they can still take your stuff because they only have to prove at this lower level, right? So many people are not convicted and they still find themselves subject to forfeitures. And sometimes you're not even dragged into court and exonerated. Sometimes you're only suspected of a crime. And they just find, hey, you know what, this would be more profitable for us. Potentially that's what they're thinking, if we forfeit the property. Still other people, not criminals, might actually be innocent third parties. And we'll get to a really interesting case about that from Ontario soon. There's no requirement in any of the laws through Canada that an individual be convicted of a crime for the property to be forfeited. So, is crime less profitable because of these laws? We see that it doesn't just target criminals. Many people who aren't convicted get subject to these, and many people who are only suspected of crimes have their property forfeited. So it's not just criminals that are affected, but, you know, what else can we say? How does it actually take the profit out of crime for criminals? Well, it certainly does for the individuals who find their property taken from them. That's obvious, at least to a degree. There's some evidence that civil forfeiture may take the profit out of certain crimes, in particular for those individuals who have their property forfeited. But in general, it increases the financial risk associated with those crimes. Now, what ends up happening then is if you're the guy who doesn't get caught, you find that your profit margins improve because now there's a restriction on the marketplace for the illegal activity that you're involved in. So increased risks result in increased profits for those individuals who actually forfeit nothing. For example, drug prices increase as law enforcement efforts are stepped up. And this means that increased profits for criminals who are able to remain one step ahead of the law. And it's interesting because there is academic research from the US, from Australia, and from the UK that has found that the civil forfeiture regimes in those jurisdictions have had little to no impact on organized crime, which is really the target of these laws. And as of 2010, Ontario hadn't even bothered to survey whether the provincial forfeiture regime was meeting its statutory goals of compensating victims. Instead of making these sorts of inquiries, like are we actually returning to victims, restitution, the civil forfeiture offices throughout Canada point the amount of money that they were able to seize, the amount of property they were able to seize, as if that were an indication of success. So look, we seized this big pile of money. We're obviously successful, but what's the purpose of the law? It's to compensate victims and make crime unprofitable. And telling us how much has been forfeited does not answer that question. So how did we get here? So if we look back into England over time, in feudal England, a person's property was the object of forfeiture to the crown when that property was used in a human fatality. So if you had an axe that killed somebody, and it was an accident, there was a cause of action called a deodand, and that axe would be forfeited to the crown. Now, there's some, the literature talks about where this may have come from, this deodand, this concept of the thing committing the crime and being responsible. And for instance, it may have come from a biblical passage, an Old Testament biblical passage that said, if a bull gores a man or a woman to death, the bull is to be stoned, and its meat must not be eaten. But the owner of the bull will not be held responsible. So, yeah.
What year are you talking in England?
This is 12th century onwards. So there's this idea that the object is responsible and the object is going to go to the crown. So under the feudal law in England, the property was figuratively given to God, and the crown actually confiscated title. But over time, this action of deodand lost much of its religious significance, and in the 19th century, it was abolished. And you can look at some of the legal writing at the time. There actually became a period in time in English history where there was deodand abuse. there would be juries and judges who would use it to punish, for instance, a railway line that caused death, and the judge would decide, well, the policy that you were using here was callous and it resulted in these deaths, so we're going to forfeit your property. So deodand was used for that, and eventually it was abolished. So there are two other antecedents to it: statutory forfeiture and attainder. And according to British law, until 1870, in the event that a person was convicted of a felony crime and sentenced to death, the felon's property would be forfeited to the Crown instead of being passed on to their heirs. Okay? And this law regarded the property of the felon as being tainted. Kind of the same idea. It goes to the object. And it's the same thing was going on in maritime law. In maritime law, where you have ships on the high seas and they're committing acts of piracy, for instance, the United States would forfeit the pirate ship, prevent that from happening. And it was difficult jurisdictionally because it was the high seas, and they didn't want to step on any other nation's authority. So they went after the property, not the people. So this is the kind of the historical antecedents for it. So some courts, or the courts, have generally characterized this cause of action as being what's called in rem. So this means against an object, and that's versus in personam, which is against a person. And that's, again, to avoid jurisdictional problems. And that's one of the interesting things, that in civil forfeiture cases, you end up with all these really hilarious names. Because it's not Derek and the Queen, it becomes whatever my property is and the Queen. So some examples out of Ontario are Ontario and 714 Railton Avenue. So it's a piece of property. Or Ontario and $29,020 in Canadian currency. They're suing the currency effectively. But if you go into the United States, where civil forfeiture has been used far more extensively, the names are far better. So for instance, the United States versus 12 200-foot reels of film. Or United States versus approximately 64,000 pounds of shark fins. And this is my favorite. United States versus article consisting of 50,000 cardboard boxes, more or less, each containing one pair of clacker balls. So it's the property that's being gone after, not the individual, and that's important. So how did we end up here in Canada? Well, 1955, the Criminal Code was amended to permit peace officers to seize, quote, anything that on reasonable grounds he believes has been attained by or has been used in the commission of an offense, but only in the execution of a warrant. So that was a step towards civil forfeiture. Now, importantly, reasonable grounds, but there has to be in the execution of a warrant. Eventually, we're going to sever that. And this is in a criminal context, don't forget. 1988, which was mentioned earlier today, Parliament provided for a more comprehensive forfeiture scheme under the Narcotic Control Act. There were some novel things that happened then. 93, Parliament consolidated the Narcotic Control Act civil forfeiture regime with the Criminal Code civil forfeiture regime. And in 2002, Parliament amended the Criminal Code simply to be about the proceeds of crime. So the Criminal Code seizure upon reasonable grounds amendment in 1955 was actually very hotly debated in Parliament. Parliamentarians knew that something new was happening here, and it was very, very hotly debated. But sadly, in some ways, the subsequent developments through the 80s and onwards were relatively non-controversial. And, in some ways, to throw them a bone, it makes sense, because forfeiture occurred post-conviction, and the higher standard of proof was used, beyond reasonable doubt. And it was all in the context of criminal proceeding. So it does make sense that it happened that way. Now, there are also some very interesting cases that brought us to where we are today. Even though Parliament had made significant amendments to the forfeiture legislation in 1955 onwards, the courts were largely unwilling to grant free rein to the federal and provincial attorneys general to administer these schemes without significant judicial oversight. Although many of the forfeiture provisions did not define what standard of proof was to be used, the courts imposed the criminal standard under the federal government's criminal law power. And that's important. In the Constitution, the federal government is given exclusive power over criminal law, Provinces cannot enact criminal legislation, okay? So we have a 1953 case, Canada and Industrial Acceptance. A drug dealer convicted under the Opium and Narcotic Drug Act. The trial court ordered the drug dealer's car forfeited since it was used to transport drugs. The convict contested the validity of the forfeiture on the grounds that it was outside the federal competency. This is actually the opposite of what's going on today. So he said, hey, you're taking my property. This isn't criminal law. This is property law. This is a provincial head of power. Well, the Supreme Court rejected that argument, and Justice Kerwin said that forfeiture of instruments of criminal activity is the domain of criminal law. It's criminal law, it's not provincial. Justice Rand, at that time, he said something even a little more, I guess, solid. He held that forfeiture is an extension of the state's power to punish and suppress the conditions of crime. The absolute forfeiture, Rand said, is inseparable. It's an inseparable accompaniment from the punitive action that the state takes. And the administration of the law would be seriously impeded were any obstacles to a prompt and conclusive action placed in the way of this enforcement. So the court at 1953 said, no, the provinces can't do this kind of stuff. This is what the federal government is allowed to do under its criminal law power. 1986. Prior to his death, Mr. Eric Fleming applied for the restoration of funds that had been seized under a warrant pursuant to the Narcotics Control Act. Speaking for the Supreme Court, Justice Bertha Wilson noted that it would be inappropriate to use the civil standards of proof when dealing with criminally tainted property. The court required that the Attorney General prove this taint against the property beyond a reasonable doubt. And failing to have done so, Fleming's property was returned to him, 1986. 92, the charter actually applies. So between 82 and 92, the federal and provincial AGs argued that the charter did not apply to forfeiture because, of course, the charter doesn't contain property rights. But the BC Supreme Court held that attorneys general were not permitted to use unlawfully obtained evidence in support of a forfeiture application, which was a way of getting the charter to apply to forfeitures. 1995. Again, 1995, we're getting pretty recent. Still at that point, the courts were imposing a higher standard of proof. The appellate courts were imposing it, at least at that time. In the case of Mack, Ontario Court of Appeal ordered the restoration of approximately $37,000 in cash. Despite the trial judge's rejection of Mr. Mack's explanation that, oh, I'm just holding it for a friend. The court held that it was not proved beyond a reasonable doubt that it was criminally tainted, so the money was returned to him. 2001, Ontario Court of Appeal affirmed that the criminal rules of evidence applied to federal forfeitures, And in that case, the Attorney General relied on expert evidence to establish that the property at issue was indeed the proceeds of crime. But the Ontario Court of Appeal again found in the defendant's favor. So there's a pattern here. The courts in Canada have repeatedly imposed more stringent standards on the attorneys general and invited but clever people, clever lawyers, these attorney general, it invited them to consider, I wonder if there's a way we can get around this. And so what they did was they envisioned a parallel legal stream, a regime that was outside of the scope of criminal law. So what they did, looking to our American friends, they created forfeiture regimes using the property and civil rights power, which is provincial. And the province legislated, all the provinces involved have legislated around many of those procedural and evidentiary standards imposed previously by the courts. And interestingly, by Parliament itself. So, previously Parliament wasn't exactly trying to get away from this. But now the provinces did an end run around what Parliament had wanted as well. And in 2009, that strategy paid off. So again, there's been a long history of the courts doing the right thing, basically, saying, no, you can't just take someone's property without a conviction or meeting that higher standard of proof. They were doing the right thing, which invited the AGs to come up with this scheme of creating a parallel civil system to do the same. regime. And so in 2009, which was a year that the Chatterjee decision came down from the Supreme Court of Canada, and this is where it all became turned on its head, and that strategy worked. Robin Chatterjee had been charged with robbery and assault and was released on bail and ordered to stay in Ottawa pending his trial. But in 2003, in breach of his bail conditions, he drove to Toronto, and when the police pulled him over because he only had one plate on his car, he was missing his front plate, he was arrested for leaving Ottawa, and the police searched his vehicle. They noted that it smelled vaguely like marijuana, and they found some money, and they also found a light ballast and a light and an exhaust fan, which tends to make police officers think there's a grow-op involved. So they seized it, and Chatterjee was not charged with any sort of offense. So I don't know if it was they didn't think they had sufficient evidence, or they thought, we can just take the money and run. I don't know what the idea there, but he was never charged. So what did Chatterjee do? He contested the constitutionality of Ontario's civil forfeiture regime. He argued that it was criminal law and outside of provincial authority. The 1953 case sure seemed to say that. 1953, Justice Rand said, look, this is a criminal law thing. Well, the Superior Court, Appeal Court, and Supreme Court of Canada each disagreed with Chatterjee. He lost at every level. These courts concluded that since the legislation was aimed at suppressing crime and compensating victims, it was properly enacted according to the province's property and civil rights power. Justice Ian Binney, speaking for the court, concluded, quote, "The province was concerned with the deleterious effects of crime in general, rather than attempting in a colorable way to tack a penalty onto the federal criminal sentencing process." So, in other words, there's a very sophisticated answer to a problem that was very clear previously. Justice Binney considered that the source of the province's legislative authority lay within that property and civil rights clause, and noted that the practical and intended effect is also to take the profit out of crime and to deter its present and would-be perpetrators. But there's strong evidence that it actually doesn't do that, but apparently that wasn't before the court, or the court didn't accept it. So in the end, it was the use of this word civil, the civil category as opposed to the criminal category, that allowed the Supreme Court to detach its conclusion from the authority of previous court decisions. Now, there's some big problems with Chatterjee, big problems. Some of them are pretty simple. In the decision, for instance, the court did not even talk about the 1953 industrial acceptance case. It didn't reference the Fleming, Mack, or West decisions that the previous Supreme Courts had arrived at. It didn't conduct any sort of historical analysis to determine what the constitutional implications of civil forfeiture was. And it didn't delve into the far-reaching implications of accepting the Attorney General's arguments that civil forfeiture actually was civil. So in the end, my take on it is that the judges were swayed by the government's argument that since civil forfeiture's regimes are intended to address victim compensation and crime prevention, and they incorporate many of the characteristics of civil law, that civil forfeiture must be civil law. They just accepted it. Now, there are many problems that result from this. Chatterjee and civil forfeiture in general is a threat to property rights, not only because it confuses civil and criminal law, but because it is a direct threat to an individual's legal capacity to possess and exchange property. Legally speaking, the court got it wrong, and really wrong. No amount of obfuscation or sophistication, in the pejorative sense of sophistication, can change the fact that civil forfeiture is criminal law. Look, it's concerned with prevention, deterrence, punishment, incapacitation. Each of these is the hallmark of criminal law. That's what criminal law is supposed to do. Merely naming it civil and getting rid of the criminal moniker, and also sneaking in this idea of it being remedial, it can't magically transform it into something it's not. There's just not enough lipstick in the world to dress up this pig. Now, civil forfeiture is also, not only is it not civil, but it's not remedial. It's punitive. It's purely punitive. generally the provinces in Canada cannot exact or enact purely punitive legislation. And that means that punitive legislation is in the exclusive power of the federal government. Now, provinces can take some sorts of punitive actions. For instance, in revoking a license. So if the province has the authority to issue the license, the province can revoke the license. So the punishment involved with that is incidental, really, to the province's power. So the punishment cannot be an end in itself and must only ever be incidental to the exercise of an otherwise provincial power, valid provincial power. So in other words, provinces are not permitted to enact purely punitive legislation. So, civil forfeiture, is it punitive or is it remedial? Well, my opinion is that it's abuse of language even that use the word remedial in the same context here. And I mean that in grab a dictionary, look it up. Is it remedial or is it punitive? If something's remedial, it means that it's intended to provide a remedy, right? That's just the definition. So legally speaking, it's intended to redress a wrong that's been suffered. Therefore, a purely remedial regime should identify an individual that's been harmed and set a quantum for compensation for that harm that's been suffered. But because no attempt is made in civil forfeiture law to identify someone who was harmed or decide how much they were harmed, the quantum of compensation owed, civil forfeiture is simply not remedial. It doesn't provide remedy. And as soon as the quantum and the harm suffered are severed, as soon as they're severed, it becomes purely punitive because it imposes penalties and inflicts injuries that are intended to incapacitate future unlawful acts. So it's not remedial, it's not civil, and there's no harm, and there's no proportionality. Now, there's some very interesting cases that have been reported by the media in recent months. And I'm going to go through some of them if you'll just bear with me. And I put them broadly into 5 categories. Where forfeiture happens, where there's no conviction, where there's no victim, an innocent third party is caught, where there's an obvious lack of proportionality between the illegal act and what's being forfeited, and then there's also perverse incentives involved. So here we go. These are all been reported. Here's the Edmonton Sun. Edmonton Sun saying, "Wow, the civil forfeiture stuff is great. It's great, and we're getting all sorts of cash and vehicles. Oh, generally it's drug dealers, by the way. Well, last I checked, people who buy pot generally want to buy pot and consider themselves not having been harmed. So it's hard to find a victim often. So it's interesting here. They're seizing the vehicles." And they're doing it at a loss. So I'm not sure who they're compensating when they're losing 50 cents in every dollar doing this. Here's another one from the National Post. Critics warn civil forfeiture gives government a license to steal. This is from Saskatchewan. You might like this one. A Regina resident was broke and his 13-year-old Chevy Blazer was out of gas. It was September 2010. All he had in his pocket was a few OxyContin tablets, legally prescribed to him as a result of an injury he suffered to his foot at work. So this guy decided, I need gas for my truck, so I'm going to go sell it to somebody. He went down the street, found what he thought was a prostitute, and sold her 2 OxyContin tablets, so he put gas in his truck. Well, she was an undercover officer. Sucks to be him. So what happened? Well, at trial, here's what the judge said. The OxyContin sale was an isolated incident. The truck seizure was disproportionate to the offense. Oh, that sounds pretty reasonable. Well, the Court of Appeal set him straight. But the Crown appealed, and in 2012, a panel of 3 judges found that the offender's offense was considerably more serious than the trial judge had indicated. So yes, he did lose his truck. So he sold 2 OxyContin tablets and lost a $13,000 bill. Interesting. And I'm still trying to figure out who the victim was there, too. And who was being compensated? Was the undercover police officer harmed, maybe? Maybe that money went right back to her. I'm not sure. Okay, well, what about harm here? This is the National Post from 2013. This is a great one. Man has undeclared $10,000 seized at border. When? After the exchange rate pushes him over the limit to take it from the country. So Robert from BC knew the amount over $10,000 must be declared at a border when taking out of Canada. And he purposely counted and calculated the exchange rate so that he was carrying exactly, in US currency, he was carrying exactly $9,880 Canadian. Well, overnight, the exchange rate changed and it became more than $10,000, so they caught him. Well, what was it? He said the money was an inheritance that he and his daughter used in their wild mushroom business. Oh, a little fishy, wild mushrooms in BC. But he always handled his transactions in cash, and it was being used to buy property abroad. He wasn't even hiding the money. He was purposely doing it to stay beneath the limit. Well, courts gave him a smackdown, and they actually called him greedy because he had that much money. And I'm not lying about that too, which is really interesting. They referred to him as, he got caught because he was greedy. Okay. I guess if you had maybe $1 less, I wonder where the greed threshold comes in. Maybe at $5,000 you're not greedy if you, I don't know. Well, victimless crimes, no convictions, and being an innocent third party. This is an interesting one. Actually, I'm gonna get the court documents for this one. This is such a great case. Oh, here we go. Second page in. So this is a family called the Rileys, and they live in Ontario, and they're horrible people because they're trying to help people who are poor. And they're trying to help people who are addicted to drugs and don't have jobs. They're trying to get them off the street, provide them with a place to live. So these are their court documents. The government has seized their properties. The properties sought are low-income housing offered to the citizens of Orillia, who are largely unable to find housing elsewhere. The Rileys have made a conscious effort to set these properties aside for marginalized members of society who struggle with addiction and mental health problems. Mrs. Riley's father was an Anglican priest in the parish of Orillia. And at that point, for 25 years with her father, she worked with disadvantaged people in the area in a hostel. Mr. Riley has worked with disadvantaged members of society. From 2007 to 2008, he sat on the City of Orillia Homeless Committee, which has a mandate of helping homeless people in the City of Orillia. Well, guess what? The government said, some of the people that you're renting your property to have done some drugs, so we're taking your property. Lost. And so they're actually in litigation right now. The property has been seized for 2 years, and they haven't been able to do anything with it. So, now, the interesting thing about that is they've done nothing wrong. They didn't do any drugs. It's their tenants, the people they rented to. So they're innocent third parties, and they're going to lose their property.
If you don't mind me asking, the property, it seems to me, would be, logically speaking, the tenant's rights under the lease. That should be what would be forfeited.
Yeah.
That would be a good argument.
Yeah, that would be a very good argument. And maybe that will actually, yeah, we would like to be involved in that case.
But since it doesn't really matter, I mean, it doesn't really matter who did what.
Yeah, it was the property that was.
Yeah, it's the property, not the person.
No,
So
but still, the property. No, the property is not the actual asset. What the tenant had was a property in a lease. They had a right to enter and exit and
Yeah.
keep the landlord out. The landlord can't enter without giving notice and so
But-
on.
It doesn't
Yeah,
matter
so
what
you-
the tenant had. It doesn't matter who had
It's
what.
what the drug had, or
Yeah.
who owned where the drug was.
Well, I still maintain that the relationship between the drug and the piece of property was the lease.
that would be a great, and then they would lose the lease.
Yeah.
Yeah, that would actually make sense. Maybe that's something we should use.
If it were an in personam action, that would make sense, but it's not. It's an in rem action. They're suing the house for having had drugs in it.
So-
Whoever happens to own the house just gets.
So here's another interesting one. This is more recent than 2 years ago. This is September 4th, 2014, Ontario, Toronto Star. Excuse me. Last summer, police pulled a man from the Toronto Harbour, apparently drunk and soaked to the bone. Valentin had allegedly steered his sailboat into another vessel parked alongside the west wall of the harbour. and fell out of his boat. Police immediately impounded the boat, and now provincial attorneys are trying to seize it under civil forfeiture laws as the target of property related to crime. Valentin has yet to be convicted under impaired driving laws, but the seizure of the boat is going ahead regardless. Now, this is the stunning part. If this case is successful, it could set a precedent with serious implication for drunk drivers both on land and water. Not only could you lose your license and be sent to prison, but you might also lose your boat or your car as well. Again, they don't have to convict you of anything. So this is the start. So this is in Globe and Mail, 2014. BC Forfeiture Office, a cash cow, former Solicitor General says. So they're just giddy about seizing people's stuff. And the former Solicitor General said they went too far at the end of the day, so he's now regretting. And the reason they went too far is they saw the profitable approach to dealing with these issues. There were ways that they could, under civil forfeiture, fund some of the crime prevention programs versus coming out of the general revenue or the Solicitor General's budget. So this article also says that in the time that BC's had a civil forfeiture office, there's been $41 million in property seized, or sorry, not seized. That's how much they profited, so they've disposed of that much. And approximately $11 million has been paid out in grants to community associations and police. So $11 million in that amount of time. So we're looking at roughly 25%. And of that 25%, there's a chunk taken by the police, because in BC, the police expect to get 10% of all revenues annually. So the police get 4.1 million of that 11. So we're down to, we're compensating victims at the tune of, what is that now, $7 million? $7 million. We've seized 41, but we're giving back 7. They're providing compensation. Now there's also problems with perverse incentives. For instance, here's an interesting article that says that depends what type of vehicle you're driving in BC, because if it's a nice vehicle, it will be seized and it will be forfeited. So, for instance, there's actually a calculation apparently that the police look at and they say, well, I can give you if you're speed or racing on the street racing, it's about $1,000 in fines we could give you, or we could take your $25,000 vehicle. And we're going to get 10% of that money. Well, seems to make sense, right? That provides them with an incentive to seize more. Here we go. 2 BC drivers lose their exotic cars. One $65,000, one $225,000. The total proceeds from both vehicles, the government's civil forfeiture office will receive an estimated $100,000. So, there's some big problems here. Again, you don't need to be convicted of anything. There's often no victim. No one's been hurt. There's no one that's getting a remedy. There's, if you're a third party, you can still be caught. There's no proportionality. $1,000 fine or a $225,000 vehicle. Something's wrong there. And there's perverse incentives. So the police have an incentive to be aggressive in their forfeiture. So, who actually gets all this money? And that's really, they could donate to the CCF maybe. That's kind of what they do. It's kind of gross. The enactment of a civil forfeiture law makes for great politics. While politicians frequently espouse the purpose of these regimes as providing another tool to combat organized crime, it also has big political advantages. It allows the government to appear to be support so-called vulnerable groups, and particularly the victims of crime, even though relatively little money ever makes it back to support them. Civil forfeiture is often also presented as cost neutral or profit generating. And as prosecutors can seize and forfeit very large items and get large sums of money. And they seem to have an indeterminate treasure chest of changing property on the horizon that they can just go out and seize property. And there's an unlimited amount of it out there, potentially. And while it may be unclear whether these civil forfeiture regimes are indeed cost neutral, they do, however, create a lot of jobs for prosecutors, police officers, and all sorts of bureaucrats. And did you know that some of the funds that are not used to cover the forfeiture schemes are used to fund the police directly, including the very police regimes that confiscate your property. So the forfeiture regime itself costs money, and the police also get their share. But where does the rest of it go? This is a concept I think I sort of came up with myself. I did read the terms in the Vancouver Sun, but I want to introduce you to the concept of a charity wash. This occurs when you take money that was controversially seized through civil forfeiture and you grant it to a charitable organization. The intent in doing so is to silence your critics by making it seem as if they're actually critiquing the charitable work that the money is being put towards. So let's take a look at where some of this money goes. Well, Alberta here. Here's Alberta, the last 3 years they're granting. So in 2014, they granted $3.1 million. Big Brothers of Calgary, Big Sisters of Calgary area, got $150,000. So what's the remedy here? Who's being helped? Ethnocultural mentoring. Okay. YouthLink Calgary Police Interpretive Center. Development of programs and supporting materials for the YouthLink facility. $500,000. GLBT Pride Center of Edmonton got $75,000 for queer youth mentoring program. And the list just goes on. You're like, are these people really victims of crime? Go back further. Well, the Mennonite Central Committee has received money. The Christ the Redeemer Catholic Separate School has received money. And all sorts of different, John Howard Society receives money from civil forfeiture. I mean, these people are very clever. They give this out to all sorts of people that are beyond criticism, effectively. Who would want to critique, the John Howard Society or the LGBT group? You don't critique that because you look like a bad person if you do it. So this is the charity wash that goes on. But they do other things with their money too. And one here, community groups profit from BC's civil forfeiture program. So here's Mr. Bond. Bond made the announcement of Richmond's Touchstone Family Association, which is getting $210,000 to continue its at-risk program for youth. Okay? Abbotsford Police Force, $24,000. $300,000 to another 6 charities in Vancouver. So this is it's adding up here pretty quickly. And the other one that makes me laugh. Oh, here it is. This is the Star. Well, wouldn't you know that if you want to go to the Mayor's Gala in Mississauga, you just need to get some civil forfeiture money to buy you a seat. So the minutes of their meetings show, for example, that the board approved buying a $4,000 table at the gala in September 20th last year. Where did that money come from? Well, the Police Services Board bought tens of thousands of dollars of tickets to private mayoral galas in Brampton, Mississauga, using proceeds of crime money that typically would go to victims and crime prevention programs. Hundreds of thousands, is that what it said? Oh, tens of thousands of dollars. Yeah, so we can go wine and dine with our friends. Trolling horses. Ever wonder about those police that ride horses around? Well, likely paid for it with civil forfeiture money. Here we go. The startup cost for the mounted unit was budgeted at $38,000. The final bill came in $14,000 less. Oh, they're being frugal. The $80,000 truck and trailer used to cart King and Watson, I presume those are the horses, from their home at Pride Stables in Deer Ridge to their office in the streets of downtown were paid for by the funds in the Civil Remedies Grant Program. So then it costs about $16,000 a year to maintain each horse. So this is where the money's going. So is it actually doing what the statute says it is? Because we've looked at all the problems. You can be caught with all sorts of, you can have your property rights infringed unjustly, but then they're not even doing what they said they're going to do with the money. So Alberta to date has collected $19 million. $3.9 million has been distributed. Where's the remainder? BC has collected $41 million to date, with $11 million being paid out in grants, and roughly 10% of total revenue is expected to go to the police. Ontario, $37 million to date, with $1.2 million distributed in grants to community organizations, and $5.7 million to the police. So in theory, civil forfeiture is premised on the idea that no one should profit from their wrongdoing. And governments supporting civil forfeiture legislation describe it as crime control or crime prevention. It permits the state to confiscate illegal profits and the instruments of illegal activities. This, proponents argue, will in turn deter crime. Good reason to doubt that, but that's what they argue. Importantly, there's no need for the property owner to be convicted. There's no proportionality between the illegal act and what they forfeit. In fact, if you're a completely innocent third party, you can be subject to forfeiture. Now, in practice, that was the theory. In practice, at best, civil forfeiture is a shortcut, allowing the state to get your stuff. At worst, it's theft. To convict someone of a crime, the state has to prove the individual is guilty beyond reasonable doubt. But to take that same individual's home under civil forfeiture, the state must merely convince the court on the balance of probabilities that the owner did something wrong. So who actually opposes civil forfeiture? Obviously, the CCF does, but there's a diverse group of people. It's a very diverse group of people, both from the political left and the political right. From the political right, opponents argue that these laws unduly interfere with property rights and involve excessive government power. But from the political left, opponents, our friends on the left argue that this regime is a colorable attempt to impose severe sanctions without protecting an individual's rights. Both sides of the political spectrum question the efficacy of these regimes. It was under Jim Flaherty's watch as Attorney General in Ontario that Canada got its first civil forfeiture legislation. At that time, my colleague Karen publicly opposed the legislation, and she wrote in the National Post in 2000. James Flaherty, Ontario's Attorney General, yesterday introduced legislation allowing police officers to seize assets without notice, without laying charges, from persons suspected of organized criminal activity. Cash, vehicle, boats, houses, or anything that an officer suspects might be the process of proceeds of crime will be subject to confiscation. At that time, in Ontario, the provincial Liberals actually opposed the legislation that Flaherty was bringing in. But once they came to power, they conveniently cozied up to it and began to love it. They became enthusiastic supporters. So this is what I want to conclude with. Note, I find this so interesting that even though civil forfeiture is a threat to property rights, it was not introduced by any sort of ideological extremist. It was political moderates. I find it so ironic that today, some of the biggest threats in civil forfeiture, some of the biggest threats to our property rights and civil liberties come from the so-called middle of the political spectrum. That's it.